Okay, so the Supreme Court case I will be talking about today is known as Bush v. Gore. Um, the constitutional question for this case is: Did the Florida Supreme Court violate Article 2, Section 1, Clause 2 of the U.S. Constitution by making new election law? And do standardless manual recounts violate the equal protection and due process clauses of the Constitution? So, for some political background on this case, it's the 2000 election, and George W. Bush was the Republican representative, and Al Gore was the Democrat representative in the running. So this case got to the Supreme Court because during the election, basically there was an instance of voter fraud, and the Florida Supreme Court ordered 9,000 ballots to be recounted by hand. These recounted ballots were undervotes, and basically what that meant is the ballots were either falsely marked or back then they used hole punches, and they would like hole punch the candidate, right? And sometimes the hole punch wouldn't go all the way through, and so it would be deemed as an undervote. Um, the recount of the ballots basically changed the election outcome, and so what that led to was candidate George W. Bush and his vice president candidate Dick Cheney requested that the U.S. Supreme Court would review the issue instead of just the Florida Supreme Court. Justices ruled Bush in favor, and the official ruling was standardless manual recounts violate the 14th Amendment's Equal Protection Clause. These were the justices that ruled in favor of Bush were Judge Rehnquist, Judge O'Connor, Judge Scalia, Judge Kennedy, Judge Souter, Judge Thomas, and Judge Beyer. And the judges that ruled against Bush were Judge Stevens and Judge Ginsburg. Apologies if I mispronounced any of those names. The dissenting opinion, I wasn't 100% sure if there was one or not, but from what I found, basically like saying that a recount would be fair in theory, but like at the end of the day, it would still be unconstitutional. The ruling was in fact long-term, because Florida's 25 electoral college points ended up going to George W. Bush, and those electoral college points ended up making him the 42nd president of the United States. And yeah. And so, as far as the importance of this case today, in a New York Times article from 2016, it basically talks about how for years there's always been a very low voter turnout. Matter of fact, 64.6% on average. And what happened is this case just made it even worse. People felt like because these instances happen and their votes might not end up counting, that they felt there wasn't really a great incentive to vote. And the essential question that I'll be answering is: Does the U.S. Supreme Court represent the will of the majority? In my opinion, it's very complicated in this instance because while some people may not get their vote counted, it would still be unconstitutional, right? So while it's unfortunate that they don't get to say that they don't get to express their voice and vote for the candidate of their choice. The unfortunate reality is that it would be unconstitutional to recount and let them and count those votes. So um, it's a very two-sided thing. I don't think it goes one way or the other.